All right, Brian, why do we litigate?
Because our clients are angry or frustrated. So I think often in the old days, there was a lot of delays. I think in the current environment, it's a lot more denials. And in the most recent few months, it's been a lot of habeas corpus cases.
A lot of unlawful detention going on. I have had clients coming to me throughout my career frustrated with how the government is handling their case. Often it's been pending 2 or 3 years with no explanation. And, they submit inquiries, they ask their congressperson what's going on, and it doesn't get them anywhere. And so pretty early on, I grew frustrated with that dynamic and started figuring out how to do these types of lawsuits. And I found them incredibly powerful in redeeming people's rights, getting them the due process that they're entitled to, making the government do its job, basically.
I think if you tell the clients that there's nothing they can do and they just have to wait for an unknown amount of time, the anxiety eats away at them. Whereas if you tell them, hey, we can do a mandamus lawsuit, really an Administrative Procedure Act delay lawsuit, but if you can do that, the price is going to be X. Yeah. The chances of success are this close to that, but it gives them a choice and it gives them a plan of action that they can take.
Right, absolutely. Very empowering for clients to know that they have an outlet, that they do. Depending on the circumstances, they might be able to get their issue in front of a real judge.
And if it's something where the client doesn't have a lot of money and it's a broad problem that lots of people have, they might be able to go out and find others in their community, whether it's a community of, say, Iranians around the U.S., maybe it's literally their local community geographically, but if you get a small group of people together, they can cost share. And they may be able to do a lawsuit, like a group complaint lawsuit, not a class action. But that may be a way to defray costs and let people get more access to justice without having to pay $10,000 up front.
Absolutely. And so immigration litigation is a hot button issue right now in particular, though immigration issues are never too far from the news. And it's a very exciting area to operate because, you start doing individual cases. Most people start with a delay lawsuit, then maybe you work your way up from there. Maybe you do a habeas, do some FOIA litigation, and then, if you keep going with it, ultimately you can do a class action, and you can even challenge a new rule that's been promulgated that, is contrary to the statute or unconstitutional, and you can actually change the law that way. For other people, not just your client. So it's a very exciting area to operate in. I think that's why it's exciting.
And it's also, what I've heard from immigration court practitioners is that they're surprised at how fair the district courts appear to be, how they're treated well, how well the court staff are happy to deal with them. It's not the in and out traffic court sort of aspect that you get with immigration court.
Right.
You get a judge who's appointed for life. That judge has 3 law clerks. There's a lot more in the system to work with, and you get your day in court and you're getting a well thought out, usually, decision from a judge. So you're not going to be in front of a judge for 12 minutes. You might be in front of the judge for 12 weeks. Right,
absolutely. However, the counterpart of that is you cannot always get in front of a judge. You have to wait for the right opportunity. There's a lot of statutes designed to prevent a district court judge from ruling over certain issues or at certain times. You have to wait for the right opportunity to get in front of a judge. And so hopefully through this course, we're going to show you guys how to do that, how to channel your case the right way, how to bring it to the right venue at the right time, and how to redeem your client's rights powerfully.
And how to manage your client's expectations. People, especially mandamus, APA, delay lawsuit clients, want things done, really fast. But federal court lawsuits could take years to resolve sometimes. And a judge might take more than a year to issue a decision sometimes. So thinking of district court as something that's going to get you a response within a matter of a couple of weeks is not a good starting point. It may be that you can get a settlement or you can get action from the government in a few weeks. But if you get a district court decision in a year or less, that's actually very fast.
Pretty good. Yep. All right. So let's talk about the types of cases that people bring relating to immigration matters. The big one is obviously delays. The immigration agencies are understaffed, under-resourced, chronically. It's no one administration's fault. USCIS is funded by fees, and they have the authority to set fees at an appropriate level that allows them to process benefits applications timely. And that's their mandate. However, it's not really done. A lot of people file their case and it seems like nothing happens. You know, I applied for a green card 3-4 years ago and nothing has happened. Or I had my interview 2 years ago and nothing's happened. So delay lawsuits is probably the biggest chunk of immigration issues that get brought.
And they're the easiest to do. I mean, some people can do them pro se. That's what, as you said, most immigration lawyers, if they have some experience, it's with a mandamus, a delay lawsuit. So they're not as hard to file, and they're more simple to litigate.
Yeah.
But they are certainly, they go up and down. There's peaks and valleys, but they never go away.
Right. And there's a good chance that if you bring the right type of delay at the right time, there's a good chance that you're going to get a settlement. And so it's an easy way to ease into federal court litigation. You help your client, and for some people, they've had their whole lives deferred, for years, not knowing whether they're going to be allowed to stay and when their case is going to be decided. So delays are very powerful to bring in federal court. Next, I would say,
complexity?
Well, maybe let's just start with importance. Okay. I think APA, so Administrative Procedure Act. The APA is basically we call it the Constitution for the administrative state. It's a short law, the Administrative Procedure Act. You should definitely read through it. It provides the basic framework for judicial review of most agency decisions.
It's about 80 years old, right? I mean, it's been around for almost a century. It's really well written. And there's a lot of case law explaining how it's applied, but it's really a fair law that seeks to constrain the agencies and make them work in a legitimate, fair way.
Yeah. Statutes give agencies great power. They have to exercise those powers in accordance with certain procedures. They can't just act overnight. And so the APA is the source of a lot of those rules that the government has to jump through. And it also provides the framework for getting judicial review of most decisions. So just to take a classic example, an I-140 petition is denied, you think it's unlawful, and you file a lawsuit under the Administrative Procedure Act. So.
Yeah, challenging denials, agency decisions that are final is sort of the core of the Administrative Procedure Act, but also a lot of what we call mandamus lawsuits, really the judges are going to grant relief under the Administrative Procedure Act, which has a section that allows challenges to unreasonable delays in processing. So APA covers pretty much the entire spectrum unless Congress has a statute in place that specifically deals, like with Freedom of Information Act, naturalization. There are certain carve-outs where Congress has said you have to sue under this provision, not the APA. But in general, APA is your delay and challenging denials that are arbitrary and capricious is the classic language.
Right. Next, we have, you alluded to FOIA. So Freedom of Information Act, if you request a record from the government, they have to give it to you, and they have to give it to you pretty quickly. They don't get to take months and years to give it to you. And so if they don't give it to you, or they don't act on your request fast enough, or if they say we don't have the records and you think that's not true, you can sue them under the Freedom of Information Act. I personally haven't done a ton of FOIA lawsuits, but I've done them here and there. A couple of nice things is the government gets a shorter deadline to answer the case, and also you can get fees if the government settles the lawsuit, whereas normally to get fees awarded, you need to win an order from a district judge granting you relief in order to get fees.
And show that was unreasonable litigation position. And yeah, FOIA is nice in the sense that you should be able to get things done quickly, but it doesn't happen. And you have to kind of pick and choose which FOIA's requests are you going to sue over. And you're going to probably end up, if it's something controversial involving immigration, you're going to maybe end up litigating the redactions or the withholdings. Mm-hmm. And there are provisions in the law that allow the government to withhold different types of information, but ultimately it's going to be up to the judge whether or not they are substantially justified in withholding information or not.
Right.
So if you can't figure out why the government's denying your client or why your client is inadmissible in the United States, you may end up doing a FOIA first, a FOIA lawsuit second, and then maybe that gives you information that you can then build an APA lawsuit for later.
Right, absolutely. Next we have naturalization delays. So there's a specific law. If you went to your naturalization interview and it's been more than 120 days, you can file a lawsuit under 8 USC 1447B. That's what we call these cases, 1447B. There's no kind of catchier term for it.
That's the INA section. There's a different USC section, but It's great because it's a very clear-cut requirement. And if USCIS, if they go ahead and schedule the interview and at least start the interview, it's kind of like jury. Once they seat the jury, once they start the naturalization interview and the testing, then they've triggered the 120-day deadline. If they cancel it before it starts, you don't have the clock is not started. But you can also, if they're not scheduling the interview, you can file a mandamus or an APA lawsuit arguing that they're taking 2 or 3 years to schedule the interview, and that's too long.
Right.
But usually it's background checks. They're looking at your client's character. They're looking at their social media posts. Yep. They're doing investigation, but they don't have a deadline.
Yes. So if you haven't had your interview yet, your naturalization interview, it's a mandamus or APA delay case. However, if you've had your interview and it's over 120 days, then it's a 1447B case. Now, what's funny about 1447B is the district judge theoretically has the power to review your naturalization application and decide it. In practice, they don't actually do that very often. They'll send it back to the agency with an order to decide the application within a certain time frame often. So the judge has that power, but they also have the power to, as I said, send it back to the agency.
And the de novo review, ultimately the judge, if USCIS denies it, you do the appeal, they deny it again. If you think that your client is going to get more fair treatment by a judge who went to law school and is appointed for life versus a USCIS adjudicator who may not have gone to law school, then you can go to court and have the de novo review, but your client has to be comfortable testifying in front of a federal court and putting these and maybe submitting to a deposition, answering discovery. So it's not the quick and dirty the immigration officer adjudication is. It's more of we could have the press attending. It's a federal bench trial essentially.
Absolutely. So you apply for naturalization. Let's say your case is denied. You have to do an administrative appeal, file form N336. And then if that's denied, then you can file a lawsuit under 8 USC 1421, right? And then the judge has the power to review the application de novo. As far as I'm aware, that's the only instance where you get de novo review in federal district court. So there's a lot of right to review in district court over naturalization matters, both delays and the ultimate decision. There's historical reasons for that. All naturalization used to be done in district court, and there was an INS examiner. And then sometime over the past couple of decades, the initial adjudication got shifted over to INS and then USCIS. But we still retain this idea that a district court is heavily involved in naturalization.
It should be, because that's where your right to vote comes from, the right to have a U.S. passport, to pass on U.S. citizenship to children. It's the core of our polity, right? So.
Right. Okay, next we have habeas.
The hot topic right now is habeas corpus lawsuits.
Hot topic right now. So habeas is to challenge the legality of your detention. And the government has to justify your detention. They have to explain the true cause of your detention. And the judge has the power to order you released. Or the judge can order, any sort of kind of intermediate relief, like transferring the person from one jurisdiction to another. Sometimes people do, like during COVID, A lot of people did conditions of detention lawsuits using habeas. There's some dispute as to whether conditions of detention is appropriate for habeas. Really, habeas is supposed to be about the legality of the detention.
Some people also try to argue that if the government's not giving you a benefit, they're holding you hostage that way. So the Supreme Court doesn't really want habeas expanded. They're more originalist on it. So you can try to make creative arguments, but the farther you stray away from someone actually in like immigration detention, the more precarious your case is going to be.
Right. So normally the trigger when you want to think about habeas is whether someone is detained. Are they in custody? All right. Now, they don't have to be physically in a jail. Being subjected to an order of supervision, I think that's custody, right?
House arrest.
Pretty unobjectionable that that's custody, right? If they're subject to restraints on their liberty that other people are not, then that is custody, right?
The nice thing about habeas is it's very inexpensive. They charge $5 for the filing fee. Yeah. It's really geared around federal prisoners, in prison filing on the back of a shopping bag. It's really the very minimal requirements to get the habeas into court. But when you're talking, and also judges will maybe even give you a hearing within 5 days and issue an order show cause with a 3-day delay or 3-day deadline saying, hey, government, you got to respond very quickly. So you get to court as fast as a TRO, even faster sometimes, but the bar is high. Yeah. You really need to have your work done ahead of time. And unfortunately, if someone gets transferred out of your jurisdiction, if you don't have the habeas pending and filed before they're transferred, the judge loses jurisdiction. Yeah. So it's a race to the courthouse to get your habeas petition filed, and then you can file a really good brief afterwards. Yeah. Often you want to file just like a pro forma petition that just to establish jurisdiction. Then you want to go write your real petition. Then you want to amend your petition. Maybe it's a motion for order show cause. Yeah. You can style it in different ways, but the bare bones you want to get filed. And if you have software that uses it or a good template, you could get that done in an hour, but you need to verify the facts in the petition, and you need to get it filed with the court. Some courts will give you summonses, other courts will do the service themselves. Right. So there's a lot of local practice that goes on too. Absolutely. All right, now we're getting into the more obscure types of cases. Federal Tort Claims Act, FTCA. That's like if one of the immigration agencies has committed a tort against you, like battery, unlawful imprisonment, something like that. Is it like a Bivens claim? It's related, but let's say, so you have to show that they violated a state tort law, that they committed a tort under state law. It's a waiver of sovereign immunity, a limited waiver of sovereign immunity as to torts committed by in the course of their federal employment. Right. Not many people do FTCA cases. They are hard. They are not for the faint of heart. When I was earlier in my career, I did a lot of delay litigation. I got easy settlements. So then I thought, FTCA, they'll settle those easily. Absolutely not. They will fight you to the death over an FTCA case, rather than ever give you any money as part of any settlement. I'm local counsel on one right now. Yeah. Let's see. Denaturalization. So if the government thinks that you got your naturalization unlawfully, they can bring a case against you in federal court. That is the only way for them to take away your naturalization. It's getting more frequent. They're finding more alleged marriage frauds, and then they are now trying to denaturalize people. Yeah. And you actually get a federal trial. I think it's usually a bench trial, but you go to federal court and you can defend it, and then the government has the burden. They have to show and prove that fraud that happened. So, right. But the DOJ will spend a lot of resources going after that. Absolutely. It's kind of a waste of their time, in my opinion, unless it's really serious, like a Nazi war criminal who's snuck in. They've all somehow aged out. Those in the 70s and 80s, there were people hiding in Ohio, hiding in Montana, and they used fake documents to come in because they always have been looking for people that were war criminals, people that had tortured people. They were never allowed to come here. Right. These are more people that either did something maybe got someone, they had a marriage that wasn't valid, and now they're a citizen, and they're going back looking at the qualitative evidence that was available when someone's green card got approved.
Right. Okay, so that's DNATs. Am I missing anything? I think we've covered both the common and the obscure ones. I
can't think of anything else. I mean, I've used APA to sue CBP, State Department, but they're all still core APA lawsuits.
Mm-hmm. Yep. All right. So those are the types of things that you can bring in federal court.